a synopsis of your argument has been supplied.
Yes,
I
Milord.
found you have supplied two copies, but almost identical with each other.
It was your lordship's pleasure to for us to make a 2-3 pages note.
Yes, that is what.
And we have also given the exhaustive one for your lordship.
Exactly. The next one is the exhaustive one.
Yes.
And Mr. Dotto, you have ended here that with that allegation of malafidis,
Yes, Milord.
that since a petitioner has not named and or impleaded any person, that was your last point of argument. Then
Right. Yes. Milord, so far as Milord, for arguing on behalf of the state, Milord, I have concluded. The only thing that I am left with is to distinguish the 7 judgments which my learned friend Mr. Dhor has relied on behalf of the petitioner. This
now
is
let
what.
me
Yes.
understand that you have concluded your submission as a respondent state. Now
Right.
you want to distinguish the judgment cited by Mr. Dhor,
Right.
of the petitioner, right?
Right.
Now let me take the judgments one after another.
Right.
প্রতীক যেগুলো দেখেছি সেই জাজমেন্টের ফাইল দেখেছি। অনলাইন আছে? আছে? Yes. Which one should I take first?
Milord, please take Milord 1959 SCC Online US Supreme Court, page 87. But all these judgments which my learned friend has cited, Milord, emanate from a principle which has been laid down by the Supreme Court of United States in this judgment. Now, Milord, here, Milord, they are relying upon Justice Frankfurter's, Milord, observation that that an executive authority must be rigorously held by the standards by which they profess its actions to be judged. Milord, these judgments have been cited. Now, Milord, I need to, Milord, distinguish under what circumstances these judgments have been delivered by various courts.
Let me understand one thing. The proposition been laid down in this US court judgment.
Yes, sir.
The other judgments cited Mr. Dhor is same proposition has been followed.
Right.
So if you distinguish this judgment, I think it will suffice for the purpose of distinguishing the other judgments also.
More or less, yes, but 1 or 2 sentences from each of the judgment.
Very well.
Now, so far as, Milord, this judgment is concerned of the US Supreme Court, Milord, this judgment, Milord, has been delivered in a case of public employment where, Milord, an employee was dismissed without following the rules of the department. Milord, the fundamental submission of Mr. Dhor, which, Milord, he has succeeded, Milord, at the earlier round, is that he is not in, or his client will not be in any public employment. That was the fundamental submission which I wanted to distinguish, Milord. I could not, before your lordship as well as before the honorable division bench. But this judgment, Milord, which Mr. Dhor refers, is in respect of dismissal from service
in public employment.
In public employment without following the departmental rules.
Let me take the note. Yes.
But kindly note down two paragraph numbers, paragraph number 1 and paragraph number 11. 1 and 11. So paragraph number 1 starts like this. This case concerns the legality of the petitioner's discharge as an employee of the Department of the Interior, so and so.
11 is more specific. Dismissal
Right,
from government service.
right. 11 is more specific. So, my
Therefore,
lord, yes,
factually distinguishable.
yes. Or primarily, my lord, I say that fundamentally, this judgment is laid down or, my lord, rendered in a case of discharge or dismissal from public employment. Now, please take the second judgment, 1975-1, Supreme Court cases 421.
75.
75-1 SCC, page 421, Sukhdev Singh.
Exactly.
My lord, I'm sorry.
Yes, 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 please.
My lord, this 75-1 Supreme Court is again, my lord, a matter relating to public employment, relating to the grievance was removal from service contrary to the statutory regulation. But paragraph 1 of the judgment gives a hint. There was a statutory regulation. There was an infraction of the statutory regulation.
They were in government service.
They were in also government service. But these are made under that ONGC, Life Insurance Corporation, etc. Please take note only one paragraph, paragraph number 67.
Paragraph number
67. But I have made elaborate submissions that our case does not involve any statute or any statutory rules. I have already made these submissions.
67 of 75.
Yes, Miller, Sukhdev Singh, 75-1 SCC.
No,
But
71,
at the
75, 1. 75.
yes, 7.
Yes.
75-1 SCC 421.
Paragraph 60.
67. Para 1 and para 67. For the foregoing reasons, we hold that the rules and regulations framed by ONGC, LIC, and IFs. I'm sorry.
Please, for one moment.
Yes.
Second judgment you have distinguished which one? 75 3 SCC or?
No, I have not gone to 75-3 as yet, Miller. The second one is which my lord is having before your lordship 75-1 SCC.
75. It is the second. No, the second one you have distinguished. Second one.
The second one is the one which I am now distinguishing.
It is the second one.
Yes, sir.
Very well. This is 1975 1.
Yes, 75(1) SCC 421.
Paragraph 1 and
67.
you'll get the hint of the fact.
Yes.
First, the first.
Whether, yes, first, whether an order of removal from service, contrary to the regulations framed under the So-and-so Act, there are three acts, would enable the employees to a declaration against the statutory corporation of continuance of service or would give rise to a claim for damages. Second, whether an employee of a statutory corporation is entitled to protection under Article 14 and 16 against the corporation. In short, the question is whether these statutory corporations are authorities within the meaning of Article 12. We are not concerned about the last two sentences. Therefore, the question was, in respect of statutory corporation, the employees thereof, what protections they would get. But the other discussions are not required. Please come to Miller para 67 right now. For the foregoing reasons, we hold that the rules and regulations framed by ONGC, LIC, and IFC have the force of law. The employees of these statutory bodies have a statutory status and they are entitled to declaration of being in employment when their dismissal or removal is in contravention of the statutory provisions. By way of abundant caution, we state that these employees are not servants of the Union or the state. These statutory bodies are authorities within the meaning of Article 12.
What is the meaning of that? By abandoned caution.
But by abundant caution, because Millard, so that Millard, the Supreme Court is not misunderstood by interpreting that these statutory corporation employees can be equated with employees of the union or the state.
Therefore, nonetheless, they were the employees under this.
They were the employees and they were governed by statutory rules. Please remember, Millard, my submission was that the rule which Mr. Dhor's client is relying before this court is not a statutory rule.
SOP is not. It is
Yes.
executive
Yes.
direction, as you have argued.
Right. Therefore, Millard, this judgment again for two reasons. Number one, here Millard statutory provisions were involved, which is not our case. Number one. And number two, again, this is a case of public employment. Mr. Dhor's consistent case is that his client would not be in any public employment.
And that is the backdrop of the earlier round of.
Right.
Now
Yes.
it is well settled.
Yes.
Dispute with regard to that, they are not the government servants.
Right. But I have not succeeded, therefore I have to accept that they are not in public employment.
Exactly. They are not public employment. Therefore, that initial challenge to the jurisdiction of this court, you could not sustain. This court has held. If that be so, if they are not in government service, whether SOP can be equated with the force of a statutory law regulation and which you are obliged to follow. These are the simple you want to say.
This is the simple case. This is simple case.
And this is the distinguishing feature of this case with that of the judgment cited on behalf of the petitioner following this court judgment, right?
Yes. Now, this was the second judgment. The third judgment is 1975-3 Supreme Court cases 503.
Yes.
Well, this is again, Milord, a case of public employment where, Milord, the issue was regarding fixation of seniority.
Yes, this is regarding fixation of seniority.
Yes. But kindly have a look to, Milord, paragraph 8 of this judgment. Now it is true that clause so and so of the memorandum was not a statutory provision having the force of law and was merely an administrative instruction issued by the government in exercise of its executive power. But that does not present any difficulty, for it is now well settled in several decisions of this court that where no statutory rules are made regulating recruitment or condition of service, the state government always can, in exercise of its executive power, issue administrative instructions providing for recruitment and laying down conditions of service. It was therefore competent to the state government to to issue clause so and so in memorandum so and so in exercise of its executive powers. And the principle to be followed in adjusting say seniority of the officers so and so.
So let me understand. Therefore,
Yes.
what this judgment is laying down, that where there is a vacuum,
Right.
when there is a vacuum,
Right.
executive instruction can fill up that area,
Right.
right?
Yes.
Therefore, competent is to issue executive directors,
Right.
laying down the principle following adjusting intercession, such as executive directions for placing the employees in a particular place, executive directions regarding their nature of job, that can be done in the absence of vacuum.
Right. Right.
If that has been done, what is its force? But there is a
Yes.
distinction feature. Such executive directions may be in relation to a government service or a service under any statutory corporation.
Right.
The quality of assignment or quality of deployment fails to attain or cannot be elevated to the status of a government service. So executive instructions that may be directed, that cannot be equated with this.
Right. Yes.
So this is the distinguishing feature.
Yes. And Milord, taking the Supreme Court's words, these executive actions are gap filling exercises. This is the Supreme Court's phrase in some other judgment, not in these judgments.
To
Gap filling exercises to
gap
fill up the void.
unknowingly, I have used it unknowingly. Gap filling unknowingly.
Then, Milord, this was the third judgment. The fourth judgment is the one which is mostly cited, is Ramana Dayaram Setty's judgment.
Yes.
This is 1979, Volume 3, Supreme Court Cases, page 489. But this is a matter, Milord, emanating from a NIT,
Emanating from?
from a notice inviting tender.
Acha.
In a contractual matter, Milord, there were certain relaxations granted. Somebody who has not participated comes and raises certain grievances before the court, Supreme Court. I mean, it went from the High Court. But Supreme Court said, Milord, a lot of things, but finally, Milord did not grant any relief.
Granting?
Finally did not grant any relief.
Acha.
But lot of principles have been argued. I mean, considered, decided. I don't want to take your lordship through all these paragraphs.
No.
Several judgments, several
Only-
principles. But finally, Miller did not grant any relief. Kindly see, Miller, the last paragraph, paragraph 36 at page 524.
That may be Mr. on factual background, but the
Yes.
proposition which has been laid down here, possibly subject to say, that the executive authority must be rigorously held the standards by which the professes its action are to be done. What was the background of it? Supposing in a tender process, some
Yes.
standard has been fixed. These are to be done. So if it is like that, then this will be a contract. So you are bound to follow the same principle or this whatever you have laid down. You have
Right.
you have shown that these are the not the cases of government employee. They are not the government employees, so these are not applicable. But what about this observation? In a
Miller,
case,
there is no quarrel with this observation. This observation or this principle of Justice Frankfurter Millard has been followed even till today.
hmm,
No dispute, no quarrel with the proposition.
no quarrel.
But the issue is, Millard, whether this proposition can be applied in the executive law field and the executive instruction be given the force of a statute to confer a right. Because, Millard, the consistent case is, or the consistent principle is, as your lordship has been pleased to observe, that executive instruction, administrative orders, they cannot be elevated to the status of a statute or a statutory rule or something emanating from the statute,
We are now
which can be enforced in court.
right. What we are now confronting that whether the executive instruction which may regulate the condition of service which
Yes,
are obliged to perform or obliged
yes,
to discharge, whether that executive instruction is required to be followed by both the parties or it is a one-way traffic.
yes. Now
That is
take a case, though Millard, I don't agree. Take a case that Mr. Dhor's client is correct in saying that you have to post me as per my choice.
exactly.
Though Millard SOP doesn't say so, but take a case that a holistic view or a holistic reading of the SOP can lead to only one conclusion, that postings or deployment is to be done as per the choice exercise. Now, if that is not done, then his right gets affected. But whether, Millard, in respect of a SOP or an executive instruction, Millard, this principle can be followed or not is the question before my lord. I have made those submissions that there is no consequences spelled out for not following it. This is one part of the submission. I don't want to
Already you have
reiterate, but
submitted.
yes.
You have submitted. Since
Yes.
actually this is a case, this 79(3) SCC, this is 3 judges bench, no?
Yes.
So this, what the principle is laid down in a tender matter, there may be some standards, some procedures have been laid down to be followed. The court is observing that it is well settled rule of administrative law that an executive authority must be rigorously held to be, that is again Vitally has been quoted. So this is not a case of government service of like that.
Right.
They are under a contract discharging their obligation to serve the state for initially 1 year, thereafter 2 years. Now,
Yes.
whether that executive instruction is rigorously to be followed or not, this is done. Now, according to your earlier part of agreement, and you have successfully demonstrated that these are the all cases cited, all relates to the government service, condition of service, or service in the statutory corporation, where there are an admitted situation that the petitioners are not government, or the particular this petitioner or the other petitions are not in government service. But this executive instruction, which is relates to
Yes,
the
sir.
tender process,
Yes.
whether you have any scope to deviate from the standard
But I will not deviate. What I am saying is, even after applying Justice Frankfurter's principle or the doctrine, but Supreme Court ultimately did not grant relief.
acha.
Supreme Court
On
has,
that
or yes,
on that score,
yes,
anywhere it has been,
reiterate, yes,
you are
yes,
not required to follow that. A deviation from that procedure will not vitiate the entire exercise of
yes,
the state or the whoever in the tenderer
yes.
anywhere in the judgment.
But the Lordship may kindly take me, Lord, paragraph number 10.
10.
Yes.
Yes.
Milord, in paragraph number 10, Milord, in the middle, that principle has been quoted.
Yes. Yes.
Please
Yes.
take after the quotation.
Hmm.
This court accepted the rule as valid and applicable in India in A.S. Ahluwalia and in subsequent decision in Sukhdev. Matthew J. quoted the above referred observation of Justice Frankfurter with approval. It may be noted that this rule, though supportable, also as an emanation, well, it should be has an emanation from Article 14 does not rest merely on that article. It has independent existence apart from Article 14. It is a rule of administrative law which has been judicially evolved as a check against exercise of arbitrary power by the executive authority. If we turn to the judgment of Justice Frankfurter and examine it, we find that he has not sought to draw support from the rule from the equality clause from the United States Constitution, but evolved it purely as a rule of administrative law. Even in England, the recent trend in administrative law is in that direction, as is evident from what is stated in pages so and so of Professor Wade's administrative law. There is no reason why we should hesitate to adopt this rule as part of our continually expanding administrative law. Today, with tremendous expansion of welfare and social service functions, increasing control of material and economic resources, and large-scale assumption of industrial and commercial activities by the state, the power of the executive government to affect the lives of the people is steadily growing. The attainment of socio-economic, I don't think the rest of that paragraph is important. Now, please take the last part of paragraph 10, about last 6-7 lines.
Hmm.
It is indeed unthinkable that in a democracy governed by the rule of law, the executive government or any of its officers should possess arbitrary power over the interests of the individual. Every action of the executive government must be informed with reason and should be free from arbitrariness. That is the essence of the rule of law and its bare minimal requirement. And in the application of this principle, it makes no difference whether the exercise of the power involves the affectation of some right or denial of some privileges. Today, the government in a welfare state is the regulator and dispenser of special services and provider of large number of benefits, including job, contract, licenses, quotas, mineral rights, etc. The government pours worth, wealth, money, benefits, service, contract, quotas, licenses. The valuables dispensed by the government take many forms, but they all share one characteristic. They are steadily taking the place of traditional forms of wealth. These valuables, which derive from relationship to the government, are of many kinds. They comprise social security benefits, cash grants for political sufferers, and the whole state scheme of the state and welfare, local welfare. Then again, thousands of people are employed in the state and the central governments and local authorities. Licenses are required before one can engage in any kind of business or work. The power of giving licenses means power to withhold them and gives control to the government or to the agents of the government on the lives of many people. Many individuals and many more business enjoy largesse in the form of government contracts. These contracts often resemble subsidies. It is virtually impossible to lose money on them, and many enterprises are set up primarily to do business with the government. Government owns and controls hundreds of acres of public land valuable for mining and other purposes. These resources are available for utilization by private corporations and individuals by way of lease or license. All these mean growth in the government largesse, and with the increasing magnitude and range of governmental function, as we move closer to a welfare state, more and more of our wealth consists of these new forms. Some of these forms of wealth may be in the nature of legal rights, but the large majority of them are in the nature of privileges. But on that account, can it be said that they do not enjoy any legal protection? Can they be regarded as gratuity furnished by the state so that the state may withhold, grant, or revoke it at its pleasure? Is the position of the government in this respect the same as that of a private giver? We do not think so. The law has not been slow to recognize the importance of this new kind of wealth and need to protect individual interest in it with that end in view. It has developed new forms of protection. Some interest in government largesse, formerly regarded as privileges, has been recognized as rights, while others have been given legal protection for not only by forging procedural safeguards, but also by confining, structuring, and taking government discretion in the matter of grant of largesse. The discretion of the government has been held to be not unlimited, in that the government cannot give or withhold largesse in its arbitrary discretion or at its sweet will. It is insisted, as pointed out by Professor Reek in an specially stimulating article, The New Property in so and so, that government action be based on standards that are not arbitrary or unauthorized. The government cannot be permitted to say it will give jobs or enter into contracts or issue quotas or licenses only in favor of those who, having gray hair or
Or no
belonging,
here.
Yes.
Or no here.
yes or no here, no here are all are discarded, or belonging to a particular political party or professing a particular religious faith. The government is still the government when it acts in the matter of granting largesse, and it cannot act arbitrarily. It does not stand in the same position as a private individual. Therefore, Millard, my respectful submission is, Millard, this is a judgment where, Millard, the Supreme Court was considering what should be the standard followed by the state in respect of contracts or in the case of distribution of its largesse.
Can I look into your approach from this angle?
Yes,
Yes,
yes, Millard.
state is obliged to follow the SOP, no doubt about it. But
Right.
will not loom large to the requirement of placing a particular doctor in a particular place to achieve the ultimate objective of this service, to get the service of the this, compulsory service of these doctors. It is
Yes.
that you will not follow, but in a particular phase, when Raiganj is in better need than the Arjikor, then this much of flexibility is always with you. That is what you possibly want to say that.
Yes, yes. This flexibility or this play in the joints is always to be left to the government.
Very well.
Because here, Millard, these judgments
Mm.
are all considering the privileges or the rights of a person. Our case is completely on a different platter altogether. Our case is that you are duty bound to render service in exchange of an education provided to you.
On the basis of your undertaking, whatever.
Yes, on the basis of the undertaking. Now, these judgments in contractual field, in the issue of, distribution of largesse, in Article 299 contracts, but these are judgments which all Millard go near to Article 299. Therefore, Millard, the principle, Millard, there is no quarrel. I don't say that the principle is bad. Question is whether, Millard, these principles are, Millard, to be invoked in every cases where there is no right. Rather, this is a case of an obligation. Our case is a case of an obligation that I have enriched myself at government expenditure. Now it is my obligation to give back. And give back to whom? Give back to the have-nots.
Got it.
So, Millard, Ramana Millard is on a contractual field. Therefore, Millard,
Mr.
and finally, Millard, with all these Millard principles being applied, Millard, remedy was not granted to
Okay.
Millard.
What was the actual reason for not granting the remedy? Can you take it in one line or?
But the one line is Millard, para 35 at page 524,
Hmm.
7 lines from the top. That is the reason. It would now be iniquitous to set aside the contract of the respondent number 4 at the instance of the appellate. But he has proved this case,
Oh,
but still,
since right or whatever the respondent number 4 has already a right was accrued in favor of respondent number 4.
yes,
That the Supreme Court do not want to disturb the position. Did not want to.
yes. But in my early days of profession, Millard, in a matter before Justice Barin Ghosh, Millard, I had proved my case. The Honorable Judge Millard made all observations in my favor and came to the conclusion that relief should be granted to my client, but finally did not grant relief, giving the reason that if I grant relief to this person, the entire system has to be altered.
No, say it is very usual. It is very usual. Not in your field of this. In a non-agricultural tenancy act, there was
Right.
moving an application order 41 rule 11 appeal before the division bench presided over Justice Bhaskar Bhattacharya. My lord,
Yes, sir.
order 41, my lord heard it for 3 days and there are
Yes.
one-liner. If a person do not get possession of a land after 23 years after purchase, no one will come to court. We cannot
Yes.
accept your appeal, whatever the situation. This is the ground reality.
Yes, yes. Now, the fourth judgment is 1993, Volume 4, Supreme Court Cases, page 25. But this is again without a case of transfer. Home Secretary UT of Chandigarh versus Dashjit Singh. But here there was a consent to transfer contrary to the rules. But again, Miller, that principle of Justice Frankfurter has been quoted, but finally again no relief granted. Now, kindly take me at paragraph 25. Now, please have a look to paragraph 14 also. This was a case where, my lord, things flow from a statute. It may be relevant to emphasize at this juncture that while the rules and regulations referred to above are statutory, the policy guidelines are relatable to the executive power of the Chandigarh administration. It is axiomatic that having enunciated a policy of general application and having communicated it to all concerned, including the Chandigarh Engineering College, the administration is bound by it. It can, of course, change the policy, but until that is done, it is bound to adhere to it. But finally, my lord, no relief granted. Again, a matter of public employment.
Yes.
But the next judgment which has been cited is of Allahabad High Court, 2018, SCC Online Allahabad, 5677. Param Singh versus State of UP. Below paragraphs 20 and 22 has been referred for the same principle. But please take note paragraph 24. But even in the context of transfer, but this is what the Allahabad High Court holds. But even after quoting Justice Frankfurter, it is tried that non-statutory direction is not enforceable in court. The transfer policy framed by the government is non-statutory guideline, therefore, it cannot be enforced. The legal position in this regard is too well settled to require reiteration, but the Supreme Court in so-and-so has taken a middle path that administrative orders are binding on state and it cannot completely ignore the instructions issued by it. Therefore, my lord, even where, my lord, Justice Frankfurter's principles are drawn, unless it is a statutory scheme, then, my lord, it is not enforceable in court. And the last judgment which my learned friend has relied is 2025 SCC Online SC 1357. State of EP versus Bhavna Tiwari. But this relates to, my lord, admission in medical college, my lord. The allegation was there were large-scale blocking of seats. But my learned friend has relied upon paragraph 14.4. Please have a look to me at 14.4.
Mhm.
These reforms directly address the concerns raised by the High Court in the impugned order and ensure that meritorious students are not deprived of their rightful opportunities. Therefore, we are not inclined to interfere with the impugned order passed by the High Court in its entirety, but deem it appropriate to issue certain directions to the concerned authorities to ensure effective implementation of the revised counseling framework, thereby upholding the principles of merit, fairness, and transparency. So this is confined to counseling, where my learned friend's client do not have any grievance in regard to the counseling. Now, assuming this is applicable, please take paragraph 16, 1(6). As held by us in para 14.4, we issue the following directions to the concerned authorities. Then where certain directions have been given. But these are all confined to counseling.
This is all about.
But yes, these are all about in my reply to what Mr. Dhor has submitted. But my one-line answer to all these judgments are that this principle is not to be applied in the abstract. The connected principles which the Supreme Court has held, our high courts have held, which I have already submitted before your lordship, will stand on a completely different footing. It can never be said, the state can never come up and say that I'll frame a policy and I'll not follow it. No state will come up and say. Justice Frankfurter's principle need not be referred to even. Without referring to that principle also, that is the obligation. But the question is where when somebody comes before the public law remedy jurisdiction to enforce a right, first there has to be a right, then infraction of that right, and then enforceability of that right. To ascertain whether there is a right or enforceable right, but one has to look into the document from which the right arises, or the nature of the document from which the so-called right arises. My case is that here there is no right, here it is an obligation. You are under the bond to serve. Whether you can say, you have to put me in place A because I have chosen place A. But my understanding of the SOP is that SOP does not say that one has to be posted in the place where, or deployed in the place that has been chosen.
Yes.
But that would amount to almost rewriting or putting words into the SOP. But these are my submissions.
Can I take it that SOP is a procedure laid down by the department,
Yes, ma'am.
followed in deployment of this kind of to get the, rather I put it, that get the service, contractual contract service.
Right.
You are usually, why you have framed it, usually you will follow it, but it does not have the mandate that gives a right to any of the candidates get a posting according to his choice or according to the merit, whatever. It is the demand of a situation which may
Right.
happen for a particular doctor or particular doctors. They would be placed in a hospital or a medical college where there is a more requirement than the college or medical college he has chosen. That is the whole approach of the SOP would be, the state's approach to the SOP is this. So factually, I want to know from you, except these 2-3 doctors, have you find out any other doctors or any other person where you felt it necessary? Factually, there are how
But
many?
there are, yes, but I'll tell you, Lord Milord, there has been a lot of instances where, Milord, after posting also, initial deployment also, Milord, there has been a transfer to some other place.
Acha. Initial.
But yes, I've given one or two examples, Milord, in the initial affidavit at the Milord inception, Milord, when I was arguing, Milord, on the point of
There are.
jurisdiction of.
There
Yes.
are. Maybe.
But Milord, please consider it, Milord.
Many doctors, senior residents have been placed under this in this go. How many?
Nobody.
No,
In
total
this-
number,
But these notifications, which is before your lordships, nobody accepting the
No,
requests.
not notification. Okay.
All other.
All. How many doctors where senior residents have been placed under this exercise? Somewhere I say 58, 59 like that.
আমাদের senior batch এর হচ্ছে 7 জন।
Well, in our batch, 871.
871. Let us understand that. In 871, total number of the senior residents, is there only 3 cases or there are
It's
cases?
only 3.
Yes, only 3 cases.
171 only 2. And in
No,
around
not even 3. Only 2.
and in around
No,
700.
I'm not hearing your case now. That is, since you have joined, I will hear Mr. Dotto on it and later.
There are, take it this way. As far as my case, that is governed under 800 and odd. I make a distinction between first time and subsequent time. So first time case, 800 plus. Affectations 2. For the second term, 700 plus.
You are not concerned.
I'm not concerned.
You are not
That's
concerned.
just for the,
You are not concerned.
yes, that's
Now, 802.
affectation 2.
Now, what has been sought to be justified that your requirement is Raiganj is more than the Arjikor. This is the simple thing
That-
I have got it from here. But can there be a situation that you may be asked to join or you may be given a deployment according to your choice? Thereafter, the state possesses a power to transfer you
Post, well, there are,
post deployment.
no, may I say this? There are 2 stages. First stage and the second stage. Both stages, there are counseling.
No, I understand. For 1 year service,
Yes.
1 year service.
Yes.
So the SOP
I have
also.
understood the lordship question. I'm
Yes.
deliberately, I don't want to answer because that has a other facets.
No,
which
I'm not
lordship
going
may
to.
yes.
I want to know that. I understand. There is nothing to do here or there. But what Mr. Dotto has indicated, even today, you have been deployed to your chosen college. Thereafter, they can transfer you to the place where there is a requirement. It is justifiable.
Yeah.
It is justifiable. If it is found that a particular establishment requires a particular type of doctor in that way, so it must be there with the state. I want to know from this is not my question. My question is whether standard operating procedure has covered such a situation.
No,
Mr. Dotto,
it doesn't.
have you heard it?
Yes, sir. Yes, my lord. But I have a short submission to make.
Yes.
Yes, my lord, the submission is, my lord, if I am right in my understanding and addressing the court so long, but unless, my lord, there is a right, there is no question of discrimination.
Of course.
Therefore, what Mr.
Yeah.
Dhor is saying, that out of 800 and odd, only 2% has been chosen out.
Okay.
You know, that can arise, or discrimination, Article 14, all these arise made out of a right. If there is no right, there is no Article 14 also. First, therefore, there has to be an establishment of right that choice of counsel place A will lead to deployment in place A. This leading to deployment at place A is missing in the SOP. This is my understanding of the SOP.
What you are saying, first of all, what is the nature of work you are discharging or you are obliged to discharge? What is the
Yes.
nature of job? You are under a bond service.
Yes.
Have undertaken before entering into the course that you will, after finishing the course, you will serve the state for 3 years. Rather, I have hired your service.
Yes.
So I want to put you in X. I have laid down a procedure how I will manage this deployment. But it does not mean that I have to follow it very meticulously, precisely, even when there is a need which has arisen in a particular for which you may deviate from that process, your choice.
Right.
And
Right.
as you have already submitted, that if offered to me, that actually indicates that your offer is not final. Ultimately,
Right.
is with the state to decide
Yes.
if it is offered. This is all about your submission. But
Yes. But only one, Millard, one addition, Millard. One addition is, Millard, the question of deviation will come, Millard, provided there is a clause that a choice will lead to a deployment. That clause is missing in the SOP. But had there been such a clause, then, Millard, the question of deviation would have arisen.
But you have invited a choice in the counseling.
Yes. Yes. This is one thing to invite somebody for a choice, and it is another thing for the government to exercise its right to deploy. But my lord will not find, at least Mr. Dhor has not been able to point out any clause in the SOP which says that as per the choice, deployment would be made. The contention is that what is the use of that choice if you do not deploy me over there? That is possibly the contention.
Exactly then.
Yes. But my answer would be that, Millard, unless that would, Millard, amount to, Millard, putting words into the SOP. If that is not in the SOP, that does not confer any right. It
No,
is only
it is not the right. You have
yes.
you laid down whatever the procedure to
Yes.
manage your own home. That I have got 1,000 similar type of senior resident. Now I have to deploy them, not but I will follow. These are the procedure. You have gone through, asked them to go through counseling. You have prepared the merit list, and ultimately given an option with a rider. Given an option to them to make a choice with a rider. With a rider, subject to availability or subject to the final offer. With a rider.
Well,
Now,
that is one part. But that is one part which I have already, Millard, highlighted.
yes.
But the other part is, assume for argument's sake that I have violated. Now, question is which provision have I violated? That is not pointed out to the court. Number 3 is, take a case that they find out a clause which I have violated. If I have violated, can they enforce a right arising out of that violation? For that, Millard, all those principles would apply. Then he has to show that it is emanating from a statute. And this is a statutory rule. This has given them an enforceable right. But my lord has not been shown any statute by the petitioners saying that this SOP flows from so-and-so statute or so-and-so rules, and it has the enforceability of a law.
No, I understand. The
Yes.
nicety of the laws and the interpretation of SOP, the right at all of the nature of the job they are supposed to discharge for the state. All you have argued very well. But a simple question I want to know from you. You don't have any obligation to justify the action at least.
Millard, take a case of promotion. Well, let us digress a bit, Millard. Take a case of promotion. I consider the case of 10 people. I have 5 posts with me. I select 5, I discard, or I don't select the rest 5. Millard, am I under any obligation to provide reason to the persons whom I am not selected?
If the promotion,
Yes.
saying the promotion, there
Yes.
must be an index, there must be a yardstick amongst the 10 whom you will be choosing.
Right.
Fine.
Right.
Now,
Correct.
at least for the sake of fairness, for the sake of the transparency in the procedure, are you not obliged to say one word? Though in this matter, you have got to justify, may not be obliged, but you have to justify. Raiganj has a greater requirement than the Arjikor. That I want to know. This is the area of justification of placing or deploying him or referring it to deployment, not to the chosen thing, but to the that is what I want to.
Millard, in these types of cases, Millard, the court has not called upon the state or the respondent to justify. But otherwise, Millard, the employer's discretion will be gone.
So according
Millard,
to
in a case of transfer,
you
in a
have
case of transfer,
to
whenever Millard I'm sorry.
state is not, or the department is not, is required to justify even the placement which deviates from the counseling, his merit position. Is it, can I take it from this one?
Millard, the issue of justification always presupposes a right and
You need
infraction
not
of that
repeat.
right.
I understand. You need not repeat. Yes,
Mhm.
Mr. Dor. It is all about.
Yes, yes.
Yes.
Mr. Dor,
But-
let me break
Yes.
for 5 minutes.
Millard, may I take your lordship's leave, Millard?
Exactly, but keep some. Oh, they are
Yes,
here.
yes, yes. My juniors are here, Millard.
Yes, you file your written,
And I will conclude today itself, and I will give my note tomorrow.
and you also give me a note, because by tomorrow.
But I don't think, Millard, we need to give any further note. But our note
No,
is
Mr. Dotto, this you have already touched, but today you may, in addition to that, what you have been recorded, a few paragraphs. Actually, the description of the judgment is, you have understood. I understand that these are all relating to service,
yes.
service which is admittedly not applicable here. Judgment is not applicable in that. So far, the last judgment of the tender, that this is not their right. If they are, there is a right has been not been accrued in favor of the petitioner by asking him to join the counseling. So whatever
Right.
2 lines, please put it by tomorrow if you can. Yes, Mr. Nag, please put it by tomorrow.
Can it
of Supreme Court.
So that 5-judge bench rules of the game. Tej Prakash.
এদিকে শো এগুলো মুছো। এটার সাথে এগুলো রেখো।
Lordship is referring
Yes, this
Sukhdev.
is
Sukhdev.
Sukhdev Singh.
Yes, yes.
In Sukhdev Singh, what is the position in the administrative law?
Paragraph 122.
Paragraph
122 of Sukhdev. Even if, leave the first two sentences, kindly start from and even if.
127.
122. It starts from the word and even. And even if Lordship has got the 1, 2, 3, 4, fifth line.
Wait, 122, na?
Yes, 122, fifth line.
That apart, it starts with
No,
that.
Maharaj, the 122 starts with that apart, correct? But I'm not on that apart. Kindly leave that sentence and also the next sentence. Kindly start from and even if, because that's the answer in the administrative law. And even if the regulations have not got the force of law.
That apart, the regulation framed by this constitution were intended to be binding upon them.
Yes.
And and where the basis
Where
on which
the basis on which the employments were made.
employment were under corporation created by statutes or for carrying on the business of public importance.
Thereafter.
They were public employment.
Yes. No, no.
Even if the regulation have not got the force of law.
Even if it is non-statutory. So exactly this is the answer. But I have a even well, first I would structure it in three. First, there are some factual incorrectness of learned Advocate General. First, I would just indicate that. Then my little submission on what learned Advocate General is trying to say is possibly not correct. And third, I shall be showing the relevant portions of the judgments to show that what I am seeking to say before your lordships, that is supported by this. These are the three segments of my submissions. The first, when facts, sentences come from learned Advocate General, then that we take it extremely seriously.
Of course.
Of course, we take it because we double check. We might be wrong. Now I have quoted it. The fundamental factual point on which the entire argument was made by learned Advocate General was twofolds. One, in the SOP, there is no word on posting. 2, this is not relatable to engagement. Meaning thereby, I'm leaving aside the analysis part. I'm on just factual part. SOP equals to counseling and counseling alone. I have quoted the words.
He has got two parts of it. One part is counseling. To that effect, your client cannot have any objection or cannot have any grievance. That has
Right.
been done.
Right.
The second part, whether the placement,
whether
of
it
the
has
deployment is
based on counseling.
counseling alone, that the SOP mandates.
Yes, that's the point. While saying, but that's a point of law, I will be making submissions. But the factual point I have quoted that there is no word on posting in the SOP. That's I have quoted. No sentence. I've got no sentence on posting. This is factually incorrect. There are 5 places. This has been specifically mentioned. It is for posting. I shall show that. Number 1. And number 2, I would say very big mistake factually. That was why Advocate General ended the entire submissions that, if I quote, Mr. Dhod never showed any violation of the SOP. That's the almost at the end. Learned Advocate said Mr. Dhod did not show that any specific portion of the SOP which has been violated.
No, first of all, if you start from this end, what is the nature of job, or what is the again we are going back to the first part, that you are under the obligation to serve the state for 3 years as you have given such undertaking under a bond.
Correct.
Now the nature of work is this, that 3 years I have to serve.
Yes.
Now the SOP is a procedure laid out that regarding how these doctors or these persons who are serving the state under a bond service would be placed in different
Yes.
areas.
Yes.
Now this standard operating procedure or procedure in whatever name you may call, it is a document which will determine, or which is a guideline to place the doctors in a particular place, the nature of job and other things, so on, so forth. Now, this is a prerogative of the state or the department, because they have hired your service.
Yes.
But by this, you have not acquired any right to get a particular, no right.
Right.
No, don't have any right.
Correct. Correct.
If you don't have any right,
Yes.
this is not enforceable under the law. This is the simplest argument he has made.
May I respond to that? The Lordship has referred to this SOP as a document. And Learned Advocate General has referred it to be, it's an executive instructions.
Whatever, it is an
The name is not the factor, but kindly visualize or look at
executive instruction.
yes, it's an executive instructions. Now, look at from this perspective. I will borrow some sentences of the Learned Advocate General and add little more. I agree when Learned Advocate General says that it's the constitution, then it's the legislations, then it's the rules and regulations, and then come executive instructions. Completely agreed. There is no quarrel on that. So therefore, constitutions comes at the top of it. Now, constitution is a piece of document. Article 14 is there. When Lordship look at SOP, it doesn't say anything about Article 14. It doesn't say it is Article 14 translated.
No, not that.
But kindly look at from this perspective. If state wants, for whatever reason, that I want some kind of equality based on merit or whatever is, in other words, if the state want that I want to follow constitutions, thereby I want to follow Article 14, they need a tool. A tool, my lord, the common persons, even the all employees or the employees, everyone is not aware as to how to achieve 14. It looks good. But to achieve that, there is a requirement of a tool. Kindly look at from this perspective. SOP is a tool to achieve Article 14. Why?
Mr. Dhor, sometimes I wonder, some rules are always existence in a civil society.
Yes. Yes.
What the constitution is doing,
Yes.
is he formulating a new rule?
No.
It is only
It
recognizing.
is. It is no. It exactly. It
It is only recognizing the
Yes.
civil society must have these rules.
Yes.
And they, of course, while uh, uh, framing or giving any executive instruction,
Yes.
in the backdrop, it
Yes.
it need not be spelled out in language
Right. Right.
that we are following Article 14 or like. In the backdrop,
Yes.
it is always there,
Yes.
even unconsciously in the mind of the executive, the person who is giving the executive
Yes.
instruction.
Yes.
In the backdrop of his mind, no, this cannot be done. There must be some adherence to the Article 14, 16, whatever has been laid down in Article 14, 16, wherever there is in the
Exactly.
Constitution.
But in fact, there is a excellent parallel. If lordships look at the right to privacy judgment, there we are Homo sapiens. Now, as lawyers, we do talk about the fundamental rights, right to life. Now, question was whether those rights, whether are born because of the constitution or the constitution is recognizing the existence of Homo sapiens rights later. Now, I'm trying to draw that. SOP is a tool, it's a mechanism which fulfills what Article 14 prescribes.
Or demands.
Yes. I could have understood whenever state comes up with an executive instructions, is bound to follow the constitution. So there cannot be a presumption. I have a discretion. Therefore, I can do or make a document which would be violative of 14, 16, etc., etc. That is simply, that presumption is not there. So therefore, to call it as an SOP does not mean it is anything lesser than what Article 14 has prescribed. Yes, there is, it is not coming from a legislation. Need not be. Because once the Article 14 has prescribed, there has to be equality. Here it is based on merit and ranking. Well, I could have understood that learned Advocate General is making out a case while stating against a person whose ranking is at the last. Because my case is admittedly, I am not the last person in the rank, so that you want to do something, you do from the last. There is some logic can happen. My rank is 24. The others ranks, those who also opted for the RG Corps, 26 and 34. So I am above them. There are 4 vacancies. Today, for the time being, if state wants to deviate, well, for deviation also has a logic. It can't be random deviation. Deviation has to start from the less meritorious.
May I read from Ramadharam Setty's case? The government cannot be permitted to say that it will give jobs to enter into contracts or issue of courts or license only in favor of those having grey hair
Yes.
or belonging to particular political party or profession a particular religious spirit. Government is still the government when it acts and matter in granting largesse, and it cannot act arbitrarily.
Yes.
That's what you are precisely want
Since
to
Lordship
say.
has taken the Ramana Daram, I would take the opportunity to answer of Lordship question why it was dismissed. It was dismissed because of delay. The petitioner came to court in November. It is in paragraph number. Kindly come to page number 523. Last 5-6 lines. It doesn't dilute in any way. Rather, it reaffirms. Starting from it is difficult. 1, 2, 3, 4, 5, 6, 7, 8. From the bottom, 9th line. That's the reason.
No, tender accepted, right accrued in favor of respondent number 4. In that backdrop,
Nothing.
it does not mean that the law proposition of law which has been laid down or been laid down has been diluted by the dismissal.
No, not. So therefore, why really? Because this is a question. Because learned Advocate General was on one part admitting, yes, this is the judgment, and this also follows the US Supreme Court, and this is the proposition. If I can make.
No,
I
Mr.
was-
Dhar, in recess, you please make it a rather segregation of this. That few of the judgments in which US Supreme Court Bitterly's case was followed,
Yeah.
where there was a case of government job, employment, and violation of the statutory rules. Executive instructions is what he wants to distinguish, that this is not a case of that. Like
That I have taken note. I would answer that. May I?
So now you proceed in your own way. Now I want to know from you regarding the SOP. The
SOP
what
is
the-
kindly call
what-
it as this is a tool.
the nature of this tool.
Yes, it's a tool. It is nothing.
Executive instruction.
Yes.
If it is an executive instruction, whether it can be elevated to the status of a statute or a regulation or like
It
that.
need not be. It need not be. This is a mechanism so that Article 14 continues to flow and spread over whoever is there. Otherwise, the Article 14 shall remain in the book. Lordship may kindly take one pragmatic view of the matter. On one hand, there are constitutions and the world of academics. On the other hand, there is the reality and the ground reality. The persons, they need to see something. For an example, even in our central computer sections, they need a piece of document. They need not see anything, any law, any judgment. They need to have a piece of document, a check sheet, which they would be following. Why? So that some mechanism is followed.
Not random.
So that random malpractice, corruptions, state cannot act individually.
The scientifically random has also a sequence.
It does. It does. Random when we don't know.
Random is a
Well,
sequence.
these sentences are so, it evaporates the other sides, not a lawyer's side. Yes.
Random.
Well, there is nothing is random.
Nothing is random.
Based on my tools, I am not able to understand. So therefore, the moment I am not able to
Even the
perceive, it is random
waves,
to me.
I was wondering, even
Yes.
the waves of the sea has a
Yes.
mechanism, has a rather asymmetry.
Yes.
Scientific, we are unable to. We cannot term it as a random one.
It is
You
nothing.
know the great test. If you make a drop of water from the same condition,
Yes.
the next one will not fall in the same place
True.
under the same condition.
True.
But you cannot say it is a random one.
No, it is
Otherwise,
not.
there will be chaos. And this theory of chaos.
Yes.
You know the genesis of the
True,
theory of
true,
chaos.
true.
It has got a scientific back.
Well, science equally recognizes a theory to the extent the tools permit. It's there are it's everything, it's dependent. Take the example of the way we see, we hear, everything. If we go deeper into anything, then we'll come to the, I mean, matter will start diluting. Then I think this is sometimes like we have to be narrow. We have to shut the other
Some
things,
faculties off.
because the madness is so subjective.
Come at to him. Sit down, theory of chaos. You have read Salmon the Weaver?
Of course. Of course.
Right.